Right. Good morning, everyone. I'm Jennifer Hyndman from York University, and it's a pleasure to be here to introduce the first of our two keynote speakers, Law Professor James Hathaway. Of course, it would also be a pleasure to introduce our second keynote speaker, Deborah Cressy, but I got to do that last month at the Center for Refugee Studies. We have a summer school there. And then you might be asking, why am I mentioning the summer school? And it's not because my boss, Susan McGrath, is sitting over there, but rather that I met Jim Hathaway a decade and a half before today at the Center for Refugees summer school where he was teaching. And I was the wild graduate student coming on and knowing nothing about refugee law. And so it really is a pleasure to note Professor Hathaway's roots, if you like. At York University, he did his LLB, his first degree in law there at Osgoode Hall Law School, and then went on to Columbia to do 2 more degrees. He returned to York again for a while in the capacity of associate dean as well as professor, and I hope I'm getting this all right. But he then was plucked from us, and we miss him in Toronto and in Canada. But he has been working, as many of you know, as a dean in Melbourne, Australia. He is currently, as per the more formal biography that is in your program, the James E. and Sarah A. Deegan Professor of Law at the University of Michigan Law School. And obviously, kind of bittersweet to say, but one of Canada's finest exports. And certainly, in my view, one of the leading refugee law professors in the English-speaking world. I don't read enough in other languages. In fact, I don't read much at all in other languages when it comes to refugee studies. But we are really, really very honored to have Jim Hathaway with us this morning, among all the plenary speakers from so many different places. But I'll let the others introduce them. Finally, I want to just mention my very favorite article by Jim, if I may, which is ironically a commentary that appeared in a newspaper that those of you who are staying in this hotel are receiving free each morning. That's to say the National Post. And it is entitled, "Why Human Smuggling is Vital," appearing in 2010. So in a context where that is not the norm, and it's an unusual venue for such an article or a commentary to appear, hopefully that will create a bit of mystery and a little bit of space. So I really invite you to warmly welcome Professor James Hathaway.
Thank you very much, Jennifer. That's a very lovely introduction. It's great to be home, if I may say so. Although, if I can start with a very apolitical comment, I did find it somewhat stunning to arrive back in Vancouver on World Refugee Day to find the Minister of Immigration announcing harsher penalties for refugees and migrants accused of deportation. There was a part of me that thought I hadn't left America until I saw English Bay and I realized that indeed I was home. But that's a fearful symbolic gesture on the one day each year we set aside to make space for recollections of those who've lost their homes and had to flee for their lives and safety, to then choose that of all days to make that announcement, I have to say, really made me quite sad. So my job this morning is not to make you sad, but it is, however, to be provocative, and that will be my first tack. I want to take you out of what I appreciate for most is the immediate reality of resettlement in Canada, and to have you think for at least 45 minutes about the broader issue of refugee protection at a global level, and about how a new way of thinking about resettlement could actually play a critical part in answering what seems to me to be a crisis in international refugee law at the present time. In doing that, I'm also going to hopefully provide you with a little bit of ammunition to answer some of what seem to me the most disingenuous critiques of international refugee law, emanating not only from this federal government, but indeed from many developed states. Because it seems to me that those of us who do in fact care deeply about refugee law ought to be concerned that the singular importance of what is in fact the most important international human rights remedy in the world today. Every year, more people are protected through refugee law than through all of the other international human rights systems put together. That regime, it seems to me, is under threat. It's under threat in part by rhetoric from governments of the developed world that are appropriating the language of global burden and responsibility sharing to further what, and I use the term advisedly, can really only be thought to be a new version of global apartheid, to borrow from Tony Richmond. Under this new regime, most refugees not only remain in the less developed world, but remain there under conditions that are generally rights abusive and often literally life-threatening. The states creating this new global apartheid have, and this is the first of the lies that I want to be clear, we are all in a position to contest, and that we do so every time we hear them, whether it's in simple private discourse at a party, whether it's in public negotiations with officials. The first claim we must simply never accept and must always challenge is the claim that refugee law only sets protection obligations of last resort. That is, that refugees can be routinely sent away by Canada or any other country so long as some other state will admit them without risk of returning them to their country of origin. That is false, and I will return to that in a moment. The second claim, and this is one we have heard far too often in Canada, is that refugees who arrive without pre-authorization are stigmatized as illegal, despite the fact that the Refugee Convention that Canada helped to draft, and to which it is a party, itself requires exactly the opposite. And third, these same governments have sought to justify their harsh and often illegal treatment of refugees arriving at their territory on the grounds, and this is a complex claim, that this harshness is necessary so that we can stop, quote, wasting, unquote, resources on those who come to us, and spend those resources instead to meet the needs of the overwhelming majorities of refugees in the less developed world, with resettlement opportunities to be made available only to those said to be most acutely in need. And I want to take up each of these three claims to begin. Again, partly so that you can answer these rhetorical claims with confidence, partly so that you can see where I think there is room for the system to be fixed. So let's begin with the first claim. There is, despite the fact that we hear this phrase, country of first arrival, branding it out by as though it were a term of art in law, this is not a notion that has any legal pedigree. There is no duty whatever on a refugee, either to seek protection in her own region of origin or in the first country in which she arrives. There is nothing. You may search as long as you wish, you will not find it. There is nothing in the Refugee Convention that so requires, nor indeed, if read carefully, is there even anything in the so-called soft law of the UNHCR's Executive Committee that so requires. To the contrary, at most, until a refugee has actually, and this is the phrase, found protection somewhere. Found meaning actually received it, not just could ask for it. And protection meaning the whole bundle of rights guaranteed by the Refugee Convention, not just not being sent home to persecution. Then the present standards of international law actually require deference to the wishes of the refugee himself or herself as to where to take her chances on getting protection. Now, I do want to be clear, as you can see from the conclusion on the screen. This is not about the refugee getting to decide where she gets to stay. It is, however, about the refugee getting to decide where she wishes to go to ask for protection. The drafters of the 1951 convention that is still a law today moved away from the old model under which the international agency made status assessments and states simply agreed to be bound by them. States were allowed to take control of that process on an individuated basis. But the quid pro quo was that the refugee got to decide which state's process to engage, and that remains the law today. So let's be clear when we hear this. There is nothing illegitimate about a refugee deciding to take her chances in a state that she perceives to be fair-minded and where her claim will be lawfully understood and assessed. Indeed, may I be blunt? Which one of us, confronted with the need to flee, would not make exactly that choice? The second point. Any refugee who arrives at a state party's territory, and indeed, I hope the Minister of Immigration is listening carefully, any refugee who comes under a state party's jurisdiction, even by introduction on the high seas by a Coast Guard cutter of that state, any such refugee is under a state's effective jurisdiction and is presumptively entitled, until found not to be a refugee, to the benefit of the Refugee Convention. The convention was brilliantly designed so that rights flow once a claim is made or in circumstances where status can be presumed until and unless a person is found not to be a refugee. It is not the reverse. As the UNHCR has eloquently said, refugee status determination simply confirms what you are. It does not make you a refugee. Efforts to resist responsibility to refugees on the grounds of the alleged illegality of arrival or presence are fundamentally at odds with the Refugee Convention's requirement that refugees fleeing from persecution are to be granted immunity from any penalties for illegal entry or presence, as you can see from Article 31 on the screen. The reason for this is very simple. It took them 3.5 years to draft this convention. That was a lot of work. The drafters knew that then as now, not a single state would issue a refugee a visa to come and make a refugee status claim. The idea that you should come lawfully is therefore impossible, because you cannot do so. You either lie about your intentions, or you come without permission to do what you are allowed to do under the treaty. The drafters knew simultaneously that states were not going to dismantle their immigration structures more generally to allow refugees to arrive. And so they agreed, in the article that you see on the screen, that so long as a refugee comes forward, makes a clean breast of her circumstances, and explains that she's in search for protection, she may not be penalized for coming without permission. I mean, in case you think this is just an aberrational, clause, there was an amazing moment in the drafting of the treaty where the Australian delegate stood up. Sorry, Paris, but I have to tell the story. And said, by the way, this treaty only applies to people that we've given pre-authorization to come, right? And all of the rest of the delegates looked around and said, hello, Aussie, have you been asleep for the last 3 years? No, that's not so. And by the way, let's add Article 31 to make sure that that perverse interpretation can never apply. The history is there for you to read. So, second point then, refugees, by virtue of the urgency of flight, have the right to arrive without permission to make a claim so long as they make a clean breast of their circumstances to authority. Once they have arrived, they may not be penalized for coming without pre-authorization. That brings me to the third claim, which is the most complex. It's sometimes said that the harshness meted out to the refugees who arrive in the developed world can be justified as part of an overarching strategy under which developed countries will reallocate protection resources away from wealthier countries, funding NGOs and lawyers and judges, etc., to the parts of the world where most refugees actually live. And quite frankly, At one level, there is something to this argument. As I'll show you in a moment, there is a grotesque imbalance in the way we allocate protective resources today between the developed and the less developed world. If the government of the developed world were actually doing what they claimed to be doing, minimizing resources here to ensure maximum resources there, there might be an ethical claim. Why is that? Well, if you look at it, we do have a massive maldistribution today. Depending on how you play the numbers, somewhere between 80 and 90% of the world's refugees are in the less developed world, with some states, Chad, Iran, Jordan, Lebanon, Pakistan, Saudi Arabia, Syria, imagine this, hosting more than one refugee for every 100 citizens. In contrast, Canada's ratio is 1 to 460. The United States and the European Union, about 1 to 1,900. And Japan, 1 to 41,000. So not only is the less developed world doing the overwhelming share of refugee hosting, but it's doing so on the basis of dollars that do not begin to compare with what we spend on refugees who are here. In rough terms, we presently spend about 50 cents a day to look after each of the refugees under direct UNHCR care in poorer states. And to be blunt, not even that minuscule budget is guaranteed, but has to be begged for each year by voluntary contributions from a small number of wealthy states. Meanwhile, and again, this is a very conservative number, we spend at least $20,000 to process and meet the needs of each one of the tiny minority of refugees able to reach the developed world. So you can do the math. In simple terms, the world now spends more than 100 times as much on a refugee that we see in the developed world as to protect a refugee that we don't see in the less developed world. That is not even on the equitable Richter scale. From the optic of hosting capacity, the picture is just as bad. If you compare the refugee population with average income levels per capita, you get a different sense of the level of financial burden. 745 refugees per dollar of average income GDP in Pakistan, for example. The toughest ratio in the entire developed world is Germany, where it's only 17 to 1. So, in circumstances like this, it shouldn't be a surprise to any of us. I'm not justifying it, I'm simply explaining it. That the situation of refugees in most of the less developed world today, where 80 to 90% of them are, is dire. In too many cases, rights abuse is rampant and rationalized on the basis of this kind of resource scarcity. There is then, in my view, a strong basis to argue that if we believe in the equal moral worth of all persons, and I trust that everyone in this room will accept that as a premise, that we ought to be interested in approaches that more fairly share resources on the basis of comparability of need rather than the luck of where you arrive. But here is where the governmental rhetoric breaks down. They say, indeed Australia says it the most loudly, that the dollars saved are being reallocated, but that is not true. Follow the food chain, it isn't there. To the extent that monies are being spent in the less developed world, they are insignificant in quantum and never binding. They're always charity, and charity that ebbs and flows with budgetary, political, and other preferences. To the point that, and you can see on the screen, countries like India have, I think, quite rightly protested that they're not about to sign the Refugee Convention, given their geopolitical locations, if the rest of the world undertakes no obligations to them, sitting in the midst of a situation that is endemically prone to receive refugees and with no guarantee of support at all from the rest of us. And to be slightly controversial, to the extent we do spend money, we all too frequently spend it to run UNHCR and other refugee camps, where, to be blunt, rights abuse is often rampant and opportunities for self-reliance, what the Refugee Convention requires, usually non-existent. Indeed, the mandatory encampment policies in which UNHCR has too often been complicit are themselves in breach of the very treaty the agency is sworn to uphold, as well as international human rights law more generally. And yet this is where we send the monies, to the extent we send them anywhere in the less developed world. The result is about a third of the world's refugees are in camps, with that number rising to more than 60% in sub-Saharan Africa. Phrasing it differently, more than 7 million refugees, think about this for a moment, more than 7 million refugees are today in what the UNHCR calls a protracted situation, meaning that they have been waiting for more than 5 years for a solution with none in sight. Now that is not what we should be funding, the continuation of that. And so if in fact someone had actually proposed a reform that would A, involve a meaningful, not tokenistic, not charitable reallocation of resources, and B, equally critical, based on verifiable respect for refugee obligations in the destination states, then I'd be the first one to see good in that transition. But what we in fact do, what the rhetoric in fact supports, is throwing money at camps in the less developed world as a sop to our consciences for the harsh treatment of refugees in our midst, even as we know that in those camps, resources do not dependably accrue to the real benefit of refugee safety, autonomy, and self-reliance, that is precisely what the convention that we've signed commits us to. The idea of using resettlement more strategically, something closer to the heart of this conference, that many developed governments have in fact at least formally embraced, is to my mind a similarly solid idea for reasons I'll return to in a moment. But let us be frank about this as well. What is on offer today are opportunities from only a fraction of the world's developed governments, and at a numerical level that does not even begin to come close to meeting the need for even what I call residual resettlement, the resettlement after not more than 5 years of waiting in hope of return. In 2010, for example, just under 100,000 refugees were settled to just 29 states, meaning that only 1 out of every 6 states that have signed the Refugee Convention participated at all. Indeed, of the just over 98,000 refugees resettled, more than 83,000 of them went to just 2 countries, being the United States and Canada. Not only is that participation in resettlement unbelievably geopolitically unbalanced, but the total number of places available for resettlement today is, to be frank, paltry. UNHCR's unbelievably, and I will explain this in a moment too, unbelievably conservative estimate is that in 2010, just over 800,000 resettlement spots were urgently needed, meaning that only about 15% of that need was actually met. But in truth, the UNHCR number is wrong. It's been politically soft-sold at a level that doesn't reflect true needs. If you remember their own statistic that more than 7 million refugees are in a protracted situation, meaning that they've been waiting for more than 5 years for a solution with none in sight, it is surely clear that the need for resettlement is more likely something like 7 times what the UNHCR estimates it to be, at least if one believes that resettlement is a morally required response to the inability to get on with one's life after a reasonable period of time in provisional protection. Viewed in this light, the fewer than 100,000 resettlement places in 2010 actually amounts to about 1% of what is actually needed, making the contribution a paltry one by any standard. Moreover, with only a few exceptions, like the women at risk and unaccompanied minor programs, it is, and I don't mean to be harsh, but we must be candid here, it is simply not the case, despite much of the governmental rhetoric, that we target resettlement efforts at, quote, those most in need, as a recent Australian publication had it. To the contrary, we recruit those we deem most suitable by reason of their education, work, or other abilities, and offer them the chance to leave the purgatory of refugee camps in Africa and elsewhere. Now, there may well be good reason under the current system to seek out resettlement cases that we think are going to work. But let's be clear. It is completely disingenuous to market those efforts as fundamentally needs-based, much less, as some governments would have it, a needs-based alternative to asylum. So let me then stand back from the critique and offer some sense of how we might begin to rebuild this regime. And I want to be abundantly clear on this point. I have, I think, sometimes been intentionally misquoted, and I want to make absolutely clear that I do not support the renegotiation of the Refugee Convention and Protocol. Let me repeat that. The current Refugee Convention and Protocol as normative instruments are completely adequate to the task. They're not always well understood. I spent 1,000 pages writing about them in the hopes that somebody would pay attention. You know, for example, do you know that refugees get property rights under international law that are actually superior to those of citizens? Yeah. There is a lot of ammunition in this treaty that neither UNHCR nor advocates have come to appreciate. It is a brilliant regime that maps the needs of refugees onto the legitimate expectations and concerns of host states. It balances them beautifully. So I am not suggesting we renegotiate those standards. The question, however, is how we reinvigorate the actual mechanisms of protection in a way that states will continue to see it as reconcilable to their self-interest, and I don't apologize for that. It is a good thing when states see a human rights regime as reconcilable to their interests. It is more likely that they will not kill it. And yet, it must be equally clear that that renegotiation does not compromise the right of refugees to access true protection. This requires us as advocates to accept some costs. And I know as I articulate these that some of you will not be comfortable with this, but this is to provoke debate and reflection. Again, I want you to remember the status quo is that 80 or 90% of the world's refugees get virtually no rights and survive on 50 cents a day. That more than 7 million refugees in the world are being held in limbo with no solution in sight. That is the ground reality. The ground reality is not people arriving in Richmond to be resettled. I wish it were, but it is not. So when we discuss transitions, we have an ethical responsibility, I think, to accept some costs in the interest of ensuring that every refugee, wherever she is treated with dignity. One American non-governmental advocate, Bill Freilich at Human Rights Watch, has, I think, appropriately referred to my proposal as dispensing with the Mercedes for 5 or 10% of the world's refugees and giving every refugee a bicycle. Now, in Vancouver, that should have resonance. So let me see what you think. The first point, and again, take a deep breath. This is food for thought. I think we need to acknowledge that in law, there is no prohibition of limiting refugee status and the rights that follow from it to the duration of risk in the country of origin. In other words, of seeing refugee protection not as an immigration path, which it is not, but as a human rights remedy. Yes, there are going to be some cases, and in your work you know them well, that called for immediate integration, unaccompanied minor refugees, the severely traumatized being the most clear examples. And yes, humanitarian principles and psychosocial research suggests, and this is really important, the need to make a commitment to the conversion of refugee status to more permanent status after roughly 5 years, even assuming all rights are respected, which today they rarely are. But even with those limitations, immediate integration for unaccompanied minors and the severely traumatized, everyone gets a permanent solution at the end of no more than 5 years in provisional protection. Even with those limitations, it remains that a conservative estimate of 50% of global asylum capacity could be regenerated by the routine operationalization of refugee law as a system of rights regarding protection for the duration of risk. I never use the phrase temporary protection. I wish everyone would throw it out of their vocabulary. You don't know if it's temporary or not. It's for the duration of risk. But that system, rather than automatic and immediate permanent immigration, would free up huge asylum capacity that is desperately needed for those who presently have nowhere to go. Second point, assuming the various procedural caveats that I've already noted, I think it is important for us to acknowledge that governments may lawfully allocate the responsibility to protect refugees between and among themselves. But, and this is a massive but, this must be a genuine rights regarding allocation of responsibility, not a simple dumping of refugees on the amorphous ground that they arrived somewhere else first, or indeed that they will be admitted and not sent away from that destination country. In particular, that operational flexibility may not under any circumstance override the core commitment to protection in the Convention, meaning that every government has a duty to allow every person wishing to claim protection as a refugee, at least provisionally, to access its territory, pending an assignment of responsibility. That means no more deterrence at the borders. That means no more turning away of ships. Everyone must have access to whatever country they can reach. It means that refugees arriving may not be stigmatized as unlawful entrants. As we have seen, they are not. They are lawful entrants by virtue of a treaty that we have freely signed. And perhaps most important, it means that account has to be taken in both the site of arrival and in any potential state to which protective responsibility is to be assigned of the full requirements of refugee and human rights law, not just, as the European Court of Justice seems to think, not just the ability to get in and be protected against refoulement. That is a very shallow understanding of protection that is not lawful under the Refugee Convention. The process of sharing out of the fiscal burdens and human responsibilities of refugee protection, moreover, cannot be unilaterally engineered by rich states and thrust onto poorer states. I want to instead propose two cornerstones for that principled reform and then open this to discussion with you. The first is that we should move away from this rather silly system that we have now that has done nothing but generate a race to the bottom of unilateral state-by-state implementation of refugee law towards a system of common but differentiated responsibility, a notion, as many of you will recognize, pioneered in international environmental law. States increasingly today make binding commitments based on common interests in areas such as free trade, security, environment, economic development, shared heritage, the idea being that they will work together to a common end. If you will, and I don't shy away from this term, a form of collective insurance, so that when they or states with which they have close ties are faced with a significant refugee influx, responsibilities of protection can be fairly distributed and the reliable availability of fiscal resources assured. More specifically, On the financial burden sharing side, a globalized system of common but differentiated responsibility would require a major binding and practically enforceable obligation. Let me say those three words again. Major, binding, and practically enforceable obligation, not just rhetoric, to shift protection dollars to the places where most protection needs to happen. Now, at the rhetorical level, you see developed governments advocating this all the time, but not a one of them has taken the initiative to design and formalize a truly binding system of resource redistribution that would dedicate at least the same quantum of funds now spent on status determination in wealthy states to the poorer regions where most refugees remain. Binding fiscal burden sharing must replace the fickleness and the unpredictability of the current charity-based regime if you have a hope of the governments of the less developed world being confident enough to remain open to the arrival of refugees. In terms of the human dimension, what I call responsibility sharing, again, I never use the term burdens for people. People are responsibilities, not burdens. We should be open, I think, to different states taking on different kinds of responsibilities. There's no reason that a one-size-fits-all approach is the only way to go. Yet that's what we continue to do today. Yes, every state needs to be open to providing first asylum, meaning letting whoever shows up at their border in until a responsibility assignment for protection has been made. But beyond that, different states could do different jobs. Many states and regions of origin, for example, remain quite open to providing protection for the duration of risk, at least for a reasonable number of years, to those arriving from adjoining states and who, in at least 50% of cases, will indeed be able to go home within the 5 years. Other governments will be willing to take the immediate resettlement obligations for the paraplegics, the severely traumatized, the unaccompanied minors, the women at risk, and others. Others will be willing to resettle those who, after 5 years, cannot safely go home, and who are therefore morally entitled to a permanent solution. I don't see there's anything unethical about different states doing different things that play to the overall need for a comprehensive responsibility assumption toward refugees. And to be candid, what I think this would mean is that for some states, and I include Canada in this group, the main responsibility, beyond allowing whoever arrives to access the process of responsibility assignment, the main responsibility would be significantly intensified refugee resettlement. But I'm talking about responsibility, not voluntarism, toward those unable to find a solution after being protected in regions of origin for the first several years. The precise allocation of burdens and responsibilities should be flexible, but based on a foundational principle that no matter how much money you put into the regime, that does not justify withdrawing from human responsibilities. Every state, albeit at different levels, contributes both fiscally and in personal terms. This regime, though, will only work if there is true oversight. And this, quite frankly, is where it's time for UNHCR to start doing its job. UNHCR was not set up as a tents and blankets agency. There are plenty of other agencies out there that can do a perfectly fine job of that. It was set up as a protection agency. Today, protection is a tail on the dog that doesn't wag it very frequently. We need the UNHCR to play the role envisaged of being the prime guarantor of protection around the world. And indeed, I would intensify that initial role by giving it the authority to oversee both the provision of responsibility allocations and fiscal requirements and assignment of those based on assessment of human rights in the destination states. It becomes, if you will, a securities exchange commission for the refugee law world and spends its resources doing protection. So we must reach agreement. This is the only UN human rights treaty in the modern era that does not have a clear enforcement structure to it. It is time we moved in that direction, and it is time that UNHCR see itself as engaged in allocating protective burdens and responsibilities in a way that ensure that nobody spends their lives in protracted refugee situations, as the UNHCR's main effort today, the funding of camps, ensures is the reality. So to conclude then, what am I suggesting we think about? This is still a convention-based regime. The main difference between what I am proposing here and most of what is on the table today is that the variants of orderliness, of structure, of systemization that governments have discussed in recent years do not begin from, nor are they primarily directed to, ensuring meaningful protection to refugees. Reform initiatives in recent years, including the failed UNHCR-led discussions, have only tinkered with the existing model rather than pursuing a comprehensive reform model that would be sustainable. The more comprehensive model that I advocate is, and again, I make no apologies for this, attentive to state interests. States run international law. Get over it. Our job is to co-opt them to see their interests as reconcilable to those of refugees, which the treaty does a brilliant job of, were it to be properly implemented. But we must be attentive to the needs not just of the rich states, not just the powerful minority, but of all states. And most fundamentally, the reform that I propose is anchored in a recognition that most refugees today, and I urge you to take away this thought, if nothing else, from my address to you this morning. It is anchored in a recognition that most refugees today do not enjoy the rights that refugee law formally guarantees them, either because they have no access to a safe state, or the safe state to which they can travel is either not really state or forces them to languish behind barbed wire with no hope of meaningful autonomy ever resuming in their lives. That is the reality that has to end. So in my view, it is our responsibility to be open to pragmatic reforms that will collectivize and share out both burdens and responsibilities to provide the human rights remedy that is at the heart of refugee law. Yes, but, and you knew I would end with a big but, we must never, ever sacrifice the entitlements of those who cannot safely remain at home. Refugee law is perhaps the world's most powerful sign of solidarity with the world's most severely at-risk people. It is the only human rights remedy that can be engaged directly and immediately by at-risk people themselves. And most of all, it is a fundamentally practical remedy that can be reconciled to the best interests of states and hence be sustainable. For those reasons, I believe it is a uniquely valuable asset which we must never allow to atrophy. And I encourage all of you, even as you engage your work with particular clients, to think hard about how what you do through resettlement could be massively intensified to be a part of the solution to the refugees that we don't see as much as to those who we do see. Thank you for your time.